Both a will and a trust, all they are is a set of instructions of what you want to happen to your property when you can no longer manage it. Because all estate planning is based on property law. What happens to your property when you can't manage it? A will, basically, again, you have to go through probate. It's a set of instructions, basically, that the clerk interprets, and you have to follow that, go through that process. It can be costly, it can be time-consuming. A trust, on the other hand, what we're really talking about is a revocable living trust. It avoids probate, number one, but also it lets you take your assets and pass them to your children in a creditor-protected manner. Protected from creditors and predators. So, for example, if you pass your assets to your child and you leave it in trust for them, then depending on what you say, they could have everything. Maybe they could have everything day one. Maybe you stage it out to them over a period of time. But as long as they keep it in the trust, even if you said they could have it day one, it's inside this box protected from creditors and predators. So if they end up having a divorce, it stays in the bloodline. It doesn't end up going out the door because of the divorce. Also, if they get in a car wreck and it happens to be their fault, they happen to hit the van full of personal injury lawyers that advertise on TV, and it's on the way to a legal seminar, it's their fault, now they're getting sued, then they can't touch the assets in the box, the assets in the trust that you've left for them. So that is the big difference. And there are a number of other things that you can do with trust planning that you can't do with will-based planning. Whether you use a will or trust, there are the other documents, what we call ancillary documents, that go along with them. That would be the health care power of attorney to make health care decisions if you can't. The general power of attorney, which is a financial power of attorney to handle your finances if you can't. A living will, which is your end-of-life choices, and a HIPAA release. Basically, those would be ancillary documents that you need whether you got a will or a trust. And even if you have a trust, you still have what's called a pour-over will, which pours assets into the trust in case something gets left out. So those are generally the most important estate planning documents. And in most cases, when we're doing planning, we're doing all of those at one time.